Well, good evening, ladies and gentlemen. Thank you for coming out this evening to be part of this evening with us. If you're watching on YouTube, we appreciate you tuning in tonight for this special evening here at the McConnell Center. My name is Gary Gregg, and it's my privilege to be director of the McConnell Center and to kick off this Constitution Day dinner for 2024. Before we do that, however, I think we need to pause for a moment and remember that 23 years ago today, America was violently attacked and 2,977 Americans lost their life. We need to stop and remember them this evening, but also stop and remember the many, many, many more lives that were upended in the aftermath of that day. I can think particularly of the spouses and the children of those almost 3,000 Americans who would never have their fathers or mothers or husbands or wives ever come home. We think of our soldiers and sailors and airmen and Marines who died and otherwise sacrificed in the wars that followed that fateful day. One in particular that I think of tonight is my friend and former student, Dan Utley. And I remember the day he came to my office and said he was dropping out of law school. He was dropping out of law school and he wanted to join the Army, and he wanted my help in getting into officer candidate school. Well, we lost Dan on a tragic night in Africa in 2012. Tonight I certainly remember Dan. I carry with me his flag from his uniform that he gave me. And I remember him and what he did in the aftermath of 9/11 for our country. Let's all take a moment, if we will, a moment of silence to remember those who we have lost in the aftermath of those planes striking the two towers and the Pentagon and that field in Pennsylvania. Thank you. Ladies and gentlemen, I would like to call on now one of Dan Utley's classmates. Dan, we named a memorial lecture series after Dan and after his passing. Tonight is the latest iteration of that memorial lecture series, and we're very privileged to have Micheal McConnell with us to deliver those remarks tonight. But ladies and gentlemen, please welcome Connie Toby, please.
Thank you, Dr. Gregg. The Center's commitment to this lecture series in Dan's honor is a testament to your leadership and those of us who knew and loved Dan. Thank you. Dr. Gregg asked me to share with you guys a little bit tonight about what Dan was like. And as I reflected, I found it really fitting that we're honoring him as we also celebrate Constitution Day. Constitution Day honors the enduring principles enshrined in our nation's founding document, as well as the extraordinary people who embody those ideals and in their lives and in their leadership. Dan was a remarkable scholar and service member who exemplified the very essence of our nation's values. he was also just like an all-around great guy. Dan was a gentleman. He was the guy who would open the door for you. He would give you his umbrella in the rain. He would just sit next to you silently if you needed a friend but like didn't want to talk. He was so great at knowing what you needed in the moment. He always left a conversation knowing more about the person he was speaking to than they would know about him. And that was because he was just inherently curious and genuinely interested in other people and learning from everyone. He also, he was in those conversations and you would think, oh wow, he's really listening and he must really agree with me. No, it didn't mean that. He was probably, formulating his points that he would come at you with a later well thought out rebuttal, but he was respectful when he did that. And so you always knew that he wasn't afraid to voice his opinions, but was going to do so in a way that was inclusive and made you reflect on your own thoughts and think more seriously about your points of view or what was happening in the world. He was confident but never smug. He would challenge you, but he would never talk down to you. He was conscientious and ethical and wise and discerning, but he was also realistic. He knew how to have a good time. And he loved the outdoors. His ideal day would have been spent at one of our national parks, hiking or kayaking, and all the things that maybe some of his classmates didn't always so much enjoy. But he would often drag me along with him. And in so many ways, Dan was just wise beyond his years. He didn't allow his ego to limit his growth and was always willing to say when he was wrong and to change course when he knew that that was the right thing to do. One thing that never changed about Dan was his passion for defending and preserving our freedoms guaranteed by the Constitution. Originally, he thought he would do that as a lawyer. And 23 years ago, this morning, we sat next to each other in Wilson Wyatt Hall, preparing ourselves to save the world one contract negotiation at a time as future lawyers, when a friend passed by and waved Dan out. And he went to the hall and then came back and waved me out to the hall. And I went out and he told me that a plane had struck the World Trade Center. And that changed the course of all of our lives and certainly of Dan's. He did not enlist right away, but that started him laying the groundwork for leaving his comfortable life in the halls of academia for an extraordinary calling of service, where he would defend the principles of our Constitution, now serving as a captain in the United States Army. So some of you might be waiting for me to tell you like a climactic story, culminating story about his life. And there are certainly many great stories that could be told, not here, maybe over a beer later. But that wasn't Dan. We aren't talking about Dan today because he scored a winning goal or climbed the tallest mountain or captured the most enemy territory in combat. We honor him and we can learn from him because of how he positively impacted those around him every day. Dan's life teaches us that the enduring legacy of exceptional leadership is characterized not just by authority, but by the ability to lead with empathy and integrity and a genuine concern for the well-being of others. So I hope that each of you can be inspired by his example and take that with you today. Thank you.
Thank you, Connie, and thanks for passing on some of Dan's life. We could all be better from so much that the way he carried himself, the way he treated others, calls us all to be better, I think. We are also honoring our SBS cohort 2024, and tonight we've got a long way to go with them. Me and Megan do. but you guys are going to have to say goodbye to them this week as we head out. And let me say that this class has been a tremendous class. It's been an honor to have been part of it already to this point. Now, the hardest part's to come because we'll be traveling and on a bus together for like 15 hours or something. So I'm going to say what I want to say now because I might change my mind. But you have done the work. You've been worthy of the money and the effort that has been invested in you by our taxpayers, by our Defense Department, by the staff here at the McConnell Center. So I thank you for that. And we'll have much more to say as we go along. But to speak for the class and to give an invocation to so that we can all eat, as you're all looking at your salads there, dying to have that salad, I know. Let me call up Captain Jalen Smith, please.
Hello, everyone. Would you all please join me in another quick moment of silence as we honor those that perished 23 years ago and that have fought and served our brothers and sisters on the front lines to protect our freedom, and then I will go ahead with the invocation. Dear Heavenly Father, we thank you for this day. We thank you for this opportunity for us to gather here as a SBS cohort and faculty and staff and scholars, and this ability to gather as free-minded people in a free country and to share in this fellowship with each other. We thank you for the sacrifices that have made this possible. We thank you for the hands that are preparing the food for us to consume tonight. And Lord, we come humbled and we come grateful that every day on this earth is earned, and we know that the price that has been paid for this. So we just thank you, each and every one of us, from the bottom of our hearts, Lord. Thank you for this day, and thank you for the days to come. And thank you for the ability to challenge and to fight for each of these days. In Jesus' name I pray, amen.
Good evening, everyone. We're going to go ahead and get started with our programming. I am Cameron McPherson, and it's my honor to serve as the chair of the McConnell Scholars Body. Tonight, it's my privilege to welcome you all here to the PNC Club at Cardinal Stadium. And I also want to extend our appreciation to those of you who are joining online. Tonight's events are a part of the McConnell Center's Week of Studying the United States Constitution and related programming on American government, as this weekend will be the 237th anniversary of the signing of the Constitution on September 17th, 1787. Tonight is also our farewell dinner to the 29 soldiers and Army civilians for our Strategic Broadening Seminar. And as we prepare to send them back to their families and their careers, I know I speak for all of us when I thank them for their service and for spending the last month with us. Tonight, it is our honor to have with us the Honorable Micheal McConnell. Michael W. McConnell is the Richard and Frances Mallory Professor and Director of the Constitutional Law Center at Stanford Law School. He is also a Senior Fellow at the Hoover Institution. From 2002 to 2009, he served as a circuit judge on the United States Court of Appeals for the 10th Circuit. He has published widely in the fields of constitutional law and theory, especially church and state, equal protection, and the separation of powers. His book, The President Who Would Not Be King, Executive Power Under the Constitution, was published by Princeton University Press in 2020, based on the Tanner Lecture in Human Values, which he delivered at Princeton in 2019. His latest book, co-authored with Nathan Chapman, Agreeing to Disagree, How the Establishment Clause Protects Religious Diversity and Freedom of Conscience, was published by Oxford University Press in mid-2023. McConnell has argued 16 cases in the United States Supreme Court. He earned his BA from Michigan State University and his JD from the University of Chicago, and he has also received honorary degrees from Notre Dame University and Michigan State. He served as law clerk to Supreme Court Justice William J. Brennan Jr. and D.C. Circuit Chief Judge J. Skelly Wright. He has been Assistant General Counsel of Office of Management and Budget, Assistant to the Solicitor General of the Department of Justice, and a member of the President's Intelligence Oversight Board. He is senior counsel to the law firm Wilson, Sonsini, Goodrich, and Rosati, and is the co-chair of Meta's Overview Review Board. Ladies and gentlemen, please join me in welcoming the Honorable Michael McConnell.
So thank you for that great introduction, but you left out the important stuff, which is that I was born and bred right here in Louisville. You mentioned my BAs and JDs and so forth, but how about my high school diploma from Wagner High School right here in Jefferson County? And so that's one thing that's important. The other thing that's important is that no, I am not related to Mitch McConnell. There was a time in my life when I bet I got that question 2 or 3 times a day. Mitch and I sat down years ago and compared family trees, and we have, who knows over in Ireland? I mean, we were all so dirt poor that nobody kept any records, but on this side of the Atlantic, no, we are not remotely related, but it's nonetheless an honor to be speaking here at the McConnell Center, and even more of an honor to be delivering the Daniel Utley lecture. I had not known of him until Gary's introduction a little bit earlier, but I'm really quite moved to be able to stand at a podium in his honor. So I don't know if you've noticed, but we are in the midst of a presidential election. It's not like the ones of my youth where you had serious people that actually made serious arguments, and you tried to figure out who might be the one who would most promote the public good looking forward. But it is what it is. But what I'm always struck by is how little comprehension there is of what the president actually does, what the president's powers are. And we do, believe it or not, much forgotten, but we do live in a constitutional republic. And a constitutional republic is one in which no one has complete power. The powers of every branch and every part of each branch are specified, not in high-level detail, but specified in a written document that we are pledged to, as a people, to follow, and the courts are the special, they're not the only ones who are charged with constitutional enforcement. We all are as citizens in a sense, but the judges have a sort of special place, and I'm honored that we have 2 Sixth Circuit Court of Appeals judges with us this evening, and I'd like them to have the special charge of when I make mistakes, please stand up and say, "You are overruled" on that point. But what I'm going to do is talk about not the presidency today, but the presidency on paper and how it came about. That's why you have this sheet of paper at your desks, and you may want to glance at it from time to time. If you just read it, I think you will find, as so many of my students comment, that it is the most sort of head-scratching and disorganized part of the Constitution. And it's really, and seems very incomplete. It's like, what is this exactly? And there's some reasons for that. The presidency was one of the hardest of all of the things for the framers in Philadelphia to work out. The single hardest issue had to do with relative power between large and small states. They worked that out, and frankly, We don't even think about that very much anymore. They did such a good job. Right. Another thing that was very hard was what to do about slavery. We still think about that a lot, not slavery itself, but the aftermath, and what they did about that wasn't so great. And maybe their failures there, are responsible for many of our issues today. The presidency occupied, as a matter of debate, a full month out of about 3 months in Philadelphia. It was very hard. Now, a lot of what they found hard was to figure out how to choose a president and how long the term would be and what the nature of impeachment would look. I'm not going to talk about any of that. What I'm most interested in and going to focus on tonight is what are the powers of the presidency. But why was this so hard for them? Think about it. 1787, when they met in Philadelphia, there had never in the history of the world been an effective Republican, and I use that not in the sense of the modern republic, a small r, meaning in a republic, there had never been an effective Republican executive in a state of significant dimensions. There had been small city-state republics, like Florence for a while and Venice for a while, and there had been tumultuous and failed republics like Rome and places in Greece, but there had never been a successful, powerful president. And they knew that the framers knew that one of the things that had been lacking under the Articles of Confederation was an executive with unity and dispatch and energy enough actually to govern the republic. And it's interesting that both Hamilton and Madison in the Federalist essays make predictions, and they say that the real fate of the United States, whether it's going to succeed or not, is going to depend upon whether there is a sound administration. It was really the executive that mattered more than anything else, and yet they had no model upon which to build. There was nothing in the history of the world that they could look to as a model. The most immediate model across the Atlantic was good old George III. That was not an attractive idea. We were getting away from that. And then there were the colonial governors. They were, if anything, more unpopular than George. The colonial governors were the source of a great deal of the discontent that led to the revolution. And then after independence, all of the states had new constitutions, and with a couple of small exceptions, they created state constitutions where the governors were very, very, very weak. They would be chosen by the legislature for 1 year. They typically didn't. Only one of them had the power of veto anywhere in the country. Only one of them had the power to make appointments. They were Madison called them mere ciphers. That was not a model, right? That was not going to work. And so, how do they do it? It's very hard to make, important things up just out of scratch, and yet they didn't have a lot to work with. And on top of that, their leading theorists, of all the men at Philadelphia in 1787, the one who had thought most deeply about issues of constitutional structure was James Madison. And he had no executive experience of any sort, and he didn't seem to be all that interested. We know this partly because he wrote a letter to George Washington just before he left Virginia to travel to Philadelphia to the Constitutional Convention. He wrote a letter to George Washington in which he laid out his ideas for what he hoped the new Constitution would look like. And a lot of our Constitution resembles what Madison wrote to Washington. Not all of it. A lot of Madison's ideas were discarded, but a lot of things made it. And there's one line in this letter in which he said, "I have scarcely conceived of what the powers of the executive will be or how it will be chosen." He just hadn't given it very much thought. And so, and it's a very hard problem because on the one hand, too weak a president means you're not going to have a country that is actually, governed. It's almost, whether it's at wartime or time of emergency or even during times of placidity, you need an executive to actually get the laws executed in order to have unity in the country, and yet give the president too much power, and it's you're one step away from tyranny. Look around the modern history. What has happened to all of the new republics around the world? So many of them have degenerated into tyranny because of some combination of excessive executive power and very often alliance with the military. That when you put the executive in charge, if he's also in charge of the army, you have that's a real recipe for problems. And they knew that. There's so much discussion of that problem. That's why some of the leading opponents of the Constitution, whom we call anti-federalists, gave themselves names like Brutus and Cato. Well, what were they saying? Well, they were reminding us of the problem of Julius Caesar. And what is the problem? What's the problem of Julius Caesar? That was the end of the Roman Republic, and it was when the leader of the army, who was also a popular political figure, disobeys the Constitution, marches his troops across the Rubicon and into Rome, and that was the end of it. And they knew that, and so Brutus and Cato were thinking that was a warning that the president in our Constitution might be dangerously close to that. He is, after all, the commander-in-chief of the armed forces. And Patrick Henry made a dramatic speech at the Virginia Ratifying Convention against the Constitution. Patrick Henry was the most eloquent opponent of the Constitution, in which he basically predicted that the president would have the loyalty of the troops and would end the republic by taking over. So in any way, it's a very hard problem. And what I'd like to do is give you just a little information. I'm surprised people don't know more about the history of how the Constitution was formed, what they were thinking, what they were doing. But I don't want to praise my talk in advance, but I bet most of you, even though you're extremely well-educated people, don't know how the presidency was put together. And so I think it's useful to know what were they thinking and what were the ideas, how did it happen? And so that's why I call this talk Constructing a Republican Executive, because that's what the framers in Philadelphia were trying to do. And now we'll see if this works. I realize you can't read all of this, but so I'll describe what we have here. But so they meet. They meet at the end of May 30th, in 1787 in Philadelphia, and the Virginia delegation gets to Philadelphia first, 10 days before there's a quorum, and the Virginians meet every day, and what we think we know is that Madison sort of led them through a project of let's do a draft. And so when the convention actually meets, the Virginians, who had been meeting for 10 days, had a proposal. And so at the very beginning, this is as soon as the business of the convention takes place, Mr. Randolph, that's Governor Edmund Randolph, says, one of the deputies of Virginia laid before the House for their consideration sundry propositions. I love the casual tune of some of this. Sundry propositions in writing concerning the American Confederation and the establishment of a national government. This is Madison's notes of the convention. This is the original source of Madison's account of what took place. So very beginning, Randolph stands up. So here's to the left, that's Edmund Randolph. He was governor of Virginia. He's quite young, he's about 32. He's quite handsome. He's from one of the leading old families of Virginia. His father was a Tory who got driven at the beginning of the Revolution, was driven out of America, forced to go back to Britain, and the entire estates were confiscated because he was a traitor. So Edmund actually didn't have any money, and he was later Washington's first Attorney General. He had a very good speaking voice. My personal opinion is that he was not actually the brightest bulb. I think, so here's Madison. Madison was about 5'2". He was 36 years old. He was very small. He had a very weak speaking voice. At the Virginia Ratifying Convention, which is close to, you actually had somebody, a stenographer there, with shorthand. And so we have very good records of what was said. You'll have Madison speaking, and then it'll say, the remainder of this speech was inaudible. Right? So he was not a good speaker, and he was also not particularly sociable. Unlike, Randolph was like the bon vivant, and, Madison would go to his rooms and pull out Polybius or Thucydides, or and work. So I think of them as being like Randolph was the president of the fraternity, and Madison is the guy who's the treasurer and secretary and does all the work and all the thinking. So Madison, we think, is the author of the Virginia Plan, but Randolph presents it, and it contained 15 resolutions, and the 7th resolution, which we call, for reasons a bit mysterious, Resolution 7, is the one about the presidency. And it was presented on the 3rd day, so this comes up on the 3rd day of substantive work of the convention, and it says, resolved that a national executive be instituted, that in addition to a general authority to execute the laws, it ought to enjoy the executive rights vested in Congress by the Confederation. Please note, by Congress, now we're not talking about our Congress, we're talking about the Congress under the Articles of Confederation, which was a body in which all the states were represented equally. This was the failed government that the Constitution was designed to replace. So two things. General authority to execute the laws. That was not a power vested in anybody under the Articles of Confederation. One of the weaknesses of that form of government is that they couldn't execute their own laws. They would pass the laws and then ask the states, pretty please, won't you execute them? Pass a tax, and they'll say, North Carolina, you need to collect, X amount of money, you go do it. Well, how well does that work? Imagine, it's sort of like the United Nations. And And in addition to that, the executive rights vested in Congress by the Confederation. And then almost as fast as this motion is made by Randolph, James Wilson of Pennsylvania, probably the greatest lawyer among the group, but also not exactly the most, he was very stiff, very arrogant, and spoke with a Scottish accent. In Philadelphia, there were riots against him, and they called him James the Caledonian. So but he's a very smart guy, and he immediately moves that the executive consists of a single person. Because note that Resolution 7 just says a national executive be instituted. It doesn't say one person. And if you look around the world, it's not unusual to have multiple executives. There were 2 consuls in Rome, right? Across the way, when the French Revolution takes place, they are going to create a directorate of 5 people. And then they're going to have a consulate of 3 people. So this was by no means obvious to them in the way it might seem obvious to us that an executive would consist of a single person, and this is his motion. And then Charles Pinckney, one of the younger delegates from South Carolina, pops up and he says he's afraid that these powers, the ones just listed in Resolution 7, might extend to peace and war, etc., which would render the executive a monarchy. Now, isn't that interesting? I haven't left anything out. This is all. Why would Charles Pinckney think that this extends to peace and war? And I see, a lot of military people here. The very first thing that comes to their mind, and which is important to them, and which will be scary to them, is peace and war. Right? That's at the heart of what they're concerned about. And he says, why, if we give these powers to this single person, this will render the government a monarchy. Now, why would he think that? Well, what are first of all, Blackstone, the leading, the book about British law, provides, and it's too small even for me to read, and I'm going to get away from the microphone, but I need to read it to you. This is Chapter 3 of Blackstone's. Can everybody hear me? Chapter 3 of Blackstone's Commentaries on the Laws of England. Chapter 3 is called Of the King and His Title. And it says, the supreme executive power of these kingdoms is vested by our laws in a single person, the king or queen. So when James Wilson moves to vest the executive power in a single person, he is using the very language that everybody in that room, we don't know, we don't remember Blackstone. My daughter, who went to Harvard Law School, once said, Dad, you talk about Blackstone, but I went through 3 years of Harvard Law School, and my professors didn't talk about Blackstone even once. He was never mentioned. And I said, Harriet, I don't think I teach a single course in which we don't talk about Blackstone. It just shows the difference between the styles of law professoring. But in any event, a single person. And so when Chuck Pinckney says, we're creating a monarchy, he's not just imagining things. That's sort of what it looks like maybe they're doing. And then let's look at those powers. General authority to execute the laws, plus the executive rights vested in the Congress by the Confederation. Well, what were those? We have to turn to the Articles of Confederation. They, of course, the people there, knew what they were talking about. And here are the executive powers. There was no president, there was no executive under the Articles, but Congress was vested with a number of powers which are associated with the executive. Determining on peace and war, that's number one. What was the first thing that Pinckney says? Peace and war. And when we say determining on peace and war, the king, even as of 1787, the king's, a lot of the old royal powers had been taken away. But even as of 1787, the king could take the nation to war without going to Parliament. And he could sign treaties without going to Parliament. In fact, the most recent, at that time, the last officer of the crown who had been impeached were Queen Anne's ministers who had negotiated a peace back in, I think it's 1712, that was considered to be perfidious. And they were impeached and sent to the Tower, but the Parliament couldn't do anything about it. The king had done it. Well, so they could punish the ministers, but they couldn't undo the treaty. If we had time, I could tell you why Brexit was messed up as a result of this very issue of whether the king still has, the queen in that case, still has a prerogative power to make treaties. It's a long story. Sending and receiving ambassadors, entering into treaties and alliances, regulating captures and prizes, granting letters of marque and reprisal, determining the value of coin and standards of weights and measures, dealing with Indian tribes, establishing post offices, appointing and commissioning Army and Navy officers, and directing the operations of the land and naval forces. Those were all vested in Congress. Now you'll note a lot of them had to do with controlling how the war was going to be prosecuted. We're talking, and they had gone through the American Revolution. What they learned, they had a committee to run the war. John Adams was the chair of that committee. They learned a lesson. I bet people, I wonder how many people in this room would disagree with the following lesson learned. You should not run a war by committee. Does anybody disagree with that? They tried to run the war by committee, and it didn't work. And that's why they vested General Washington. They made General Washington the commander-in-chief, was precisely in order because they realized that vesting this power in Congress did not make any sense. But anyway, those are the powers. And every one of these were powers that were still held by King George as a prerogative power. Just look it up in Blackstone and you'll see it there. And so you can see that Charles Pinckney was not just making it up. When Charles Pinckney said, "Oh, this is scary because this is going to create, we're going to create, the executive is going to be a monarchy," he had solid reasons for why he said that. Well, how did they all react? As soon as Pinckney spoke, this is one of my favorite moments in the whole Constitutional Convention. I love this. A considerable pause ensued. It's the only time all summer that you don't have a bunch of people jumping up and wanting to get the floor. A considerable pause ensued. Why? It was just so damned hard. nobody, because what Pinckney said was true, and yet they didn't know how to solve it. They didn't have any models. Madison hadn't given it any thought. It was really important, and yet they didn't know what to do. And then to make things really hard, General Washington is sitting there in the front row. He had just been made chair of the Constitutional Convention. And everybody knew that he was going to be the first president. So how do you talk about the dangers of tyranny from a powerful president when everybody's going to think you're talking about George Washington? Just like today, if we talk about the president, everybody immediately translates it politically to whoever the president is, even if we're making a general point, right? So so Washington's sitting right there, and so they don't know what to do. And then first Benjamin Franklin, and then we could talk about why these particular individuals were the ones, but then John Rutledge of South Carolina, the most effective wartime executive, they sort of urge people, you got to speak. This is important. We have to be able to talk about it. And then there are a series of comments in response to Pinckney. So Rutledge says that he favors a single executive, but he was, quote, not for giving him the powers of war and peace. James Wilson speaks again, and he says that he did not consider the prerogatives, the powers of the British monarch as a proper guide in defining the executive powers. So he says, let's not give the executive all the royal powers. We need to think about this and reconsider. Madison himself proposes letting Congress decide which of the prerogative powers are going to be given to the president. So all three of these leading figures, they're trying to think of a way to get around the problem that Pinckney has posed. Well, the rest of them sort of go for the extreme. Pinckney has scared them, and they adopt powers of the president are to carry into execution the national laws, just to be the law executor, to make a certain number of appointments, but not to appoint the judges, not to appoint ambassadors, only relatively minor people, and then a veto subject to override. Nothing else. Think of what the presidency would look like if all the president did was execute what Congress said to do, appoint a few people, and veto. Where's foreign affairs? Where's commander-in-chief? Right? Where is the power to direct the agencies and the bureaucracy? Where's the power to produce a program which you then try to get through? Anyway, it would be a pathetically weak president. But that was adopted, and between June 4th and the middle of July, they talk a lot about how to elect a president and what the term should be and so forth, but they do not even touch, they do not debate one day. Nobody even mentions what are the powers of the president. They just leave it the way it was, which is a pathetically weak presidency. And then in the middle of July, the Constitutional Convention appoints something that they called the Committee of Detail. This was, ladies and gentlemen, the most misnamed committee in American history. They said they were charged with sort of putting together all of the votes that had taken place up until the middle of July and just sort of putting it together and working out the details. But the membership of this committee were very experienced, practical, hard-driving, ambitious people with ideas. And fully 2/3 of the text that came out after the Committee of Detail reported was new. They made up. They just made it up. 2/3 of the text, including some of the most important structural provisions. Almost all of our federalism principles come out of the Committee of Detail. For example, the Necessary and Proper Clause comes out of the Committee of Detail, and they completely rewrite the presidency. Now, they did this in 10 days behind closed doors with no notes. So we don't know. And when I first studied the history of the convention, because we didn't have any notes, the leading histories of the convention treat the Committee of Detail as, okay, it's just a sort of an interregnum, right? But that's where it really happened. Now, I said they have no notes. We don't even have private letters. We have very little, but we do have this. We have 3 drafts of the Constitution that were written by them. The first one is written in Edmund Randolph's handwriting with emendations, crossings out and, changes and so forth, in Rutledge's handwriting. Rutledge was the chair. I should just say, nobody's ever heard of Rutledge. You should have. He didn't speak much, but he was the most effective wartime governor, and he knew how to get things done. He was one of these guys who doesn't make speeches. He just serves on the committee and he gets his way. Very effective delegate, and he's the chair. So you see his emendations, and then the second draft is in Wilson's handwriting. And unfortunately, we don't have a full draft, and we're missing the executive power section. That's terrible news. And then there's a third draft, which is also in Wilson's handwriting and also with emendations from Rutledge. So when you look at these 3 drafts and what they change, that's how we can figure out what they did, and we can infer the logic of what they were doing. But it involves a certain amount of speculation, because it does happen behind closed doors. But note that of the people, 3 of them had participated in that debate about executive power on the very first day, right? So they had already told us what they thought, and then Gorham and Ellsworth, both from Connecticut and Massachusetts, both from New England, are added to the mix. So what does the Committee of Detail do? First of all, so they create Article 2. You have it in front of you, the entire thing, but I'm going to call attention to what they did. The executive power shall be vested in a President of the United States of America. So, and then they list certain prerogative powers, Commander-in-Chief, pardon, opinions in writing. Then there's certain prerogative power. By the way, so when I say a prerogative power, what this means legally speaking is it's a power that the president exercises, or the king exercises by virtue of his office, and does not require, Congress doesn't have to give him any power to do it. And in fact, Congress can't take it away either. So the pardon power, for example, the president just exercises it and sometimes abuses it. It's been abused a lot over even modern history, but Congress can't do anything about it because it's vested in the president. The veto is a prerogative power, and then there are others. And there's some prerogative powers that are then subject to the advice and consent of the Senate, principally the making of treaties by 2/3 vote, and the appointment of principal officers and judges by majority vote of the Senate. And then there are duties of the president, and duties can carry with them powers, right? In order to carry out a duty, you very frequently need the power that underlies that. And so for the power to take care that the laws be faithfully executed is a duty. He shall take care. He doesn't have the option to execute the laws. But on the other hand, determining how to do that, has a lot of discretion involved. So a lot of power as well as just responsibility. And so the committee uses basically 3 devices in order to restrain the power of the president. The first is that it vested many of the royal prerogative powers in Congress rather than in the president. When I read down that list of the powers that were vested in the Congress under the Confederation, those of you who know your Article 1, Section 8 of the Constitution no doubt were reminded many of those are right there given to Congress. Weights and measures, post office, and very importantly, who has the power to take this country into war? The Congress has that power, even though you'd never know it for the way we've operated since the Korean War. But this is one of the more serious, in my opinion, totally my opinion, one of the more serious ways in which our current system departs from the paper that you have in front of us. Congress is required to has the power to take us into war. The president can't just do it on his own authority, even if they have done that now something like 30 times. When the Libyan war began, President Obama spent 3 months negotiating with NATO members, NATO allies, about going to war and did not go to Congress. And Constitution doesn't actually say anything about NATO powers, but it does say the president has to get Congress's declaration. So anyway, many, and in fact, of the, depending on how you count them, one scholar, this isn't my number, but one scholar calculated that 13 of the 27 specific powers enumerated in Congress were in fact royal executive powers. So that's quite a few, and those are given to, so one device is we're not giving the president all of the suite of royal powers. A lot of them are going to Congress, including peace and war, the ones that set off the debate. And then secondly, it trimmed down even the prerogative powers that it specifically vests in the president. It trims down vis-a-vis what the king had. I'll talk about that in more detail in just a second. And then finally, it vests the residual executive power, which this is an extremely controversial thing I'm about to say. I'm giving you my opinion. Lots of law professors disagree with that. But my opinion is that this refers to all of the powers of an executive nature that were not vested elsewhere, and that they are then given to the president. But, again, this is my theory, that these are not given as prerogative powers, but rather are given to the president subject to the ability of Congress to exercise its delegated powers in ways which may contradict what the president has done. Controversial example from the War on Terror, Guantanamo, and so forth. So President Bush exercised certain powers of an executive nature having to do with setting up tribunals and what we're going to do with illegal combatants and detainees and so forth. He probably had the power to do that, but Congress specifically is delegated the power to make rules for the regulation of the conduct of the armed forces. Those of you in uniform, I'm sure, are extremely familiar with this. This is how the Code of Military Justice comes about. This is why the armed forces are governed in the way that they are. Congress has this power, and when Congress exercises that power, it trumps anything that the president does by virtue of his residuary executive powers. This is my theory. I think it's right, but there are those who would disagree with it. But I think that's one of the things that the Committee of Detail did, was to have this third category, sort of a catch-all category, in which the president has the power sort of to be the first mover, but subject to congressional override. So I think those are the three principal devices. I know you can't read this, but you can see the list. Let me just tell you what it looks like. So, prerogative powers of the king. These lists are right out of Blackstone. These are powers that the king had, and the list on the left are the powers that Congress, through the Committee of Detail, assigned to Congress. Look how long that list is. And then the powers, then some of those powers are given to the president. Those are on the right. And then there are also duties assigned to the president. And then even this is the second device, even the prerogative powers are limited relative to the king. And I can't go through all of these, but I think they're rather interesting. It just shows how attentive to detail the Committee of Detail was. Let me just begin with the one that might be of particular interest to this audience, namely Commander-in-Chief. The President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into the actual service of the United States. Now, the king was Commander-in-Chief of not only the regular army, but of the militia as well. So this is a departure from the British system. There's a separate militia clause in Article 1. The states, the militias were under state authority. Our National Guard is a kind of perverted, weird descendant of what the militias were. But the states had militias. The states decided who would be in them. The states chose their officers, so they were run. The militias were not under the command of any federal person. This is how the modern National Guard is quite different. But the militias were not under control of federal military officers other than the president himself, and then only when the militias were called into active service of the United States. And the Constitution provides that only Congress can provide for that, and only under 3 specified circumstances. Most of the time, the militias remained in the states and were used by the states for their own purposes of self-defense, to put down insurrections, to guard against Indian raids, to enforce the laws, and so forth. They were state institutions. Now think about that for just a moment, and think about the Julius Caesar problem, which was so much on their minds. The regular army of the United States, through the end of the 18th century, rarely exceeded very many more than 1,000 soldiers, most of whom were stationed on the frontier, guarding against Native American raids. 1,000. There was no Navy until Jefferson. So it's a tiny army. And one of the most chilling of the Federalist essays, 45, Madison is saying, oh, the states actually are more powerful than the federal government militarily, and here's why. He says, he calculates that the largest number of men that the United States could put into arms at one time, given the population at the time, and make various calculations that I don't know quite where he gets them from. But in any event, the largest number, right, is something like 20,000. And he says presently, the militias of the states are 500,000 men in the militia. And then he goes on to say, under officers of their own choosing, right? So the Julius Caesar, they solved the Julius Caesar problem through the commander-in-chief clause by, in our country, the president may be commander-in-chief of the army, but that doesn't mean that he has control over, the military might of the country. That instead is off in the various states in the form of the militias. I think that's ingenious. It is not until the Civil War that the federal army, the standing army, becomes larger than the militias, and the militias are subsumed into that. So for decades, the system actually works. Each of the prerogative powers has its own sort of limitations. Pardons, for example, only apply to pardons against offenses against the United States. The king could pardon offenses anywhere. There were no states. So the president cannot pardon state offenses. That's why the prosecution in New York against Trump and by Fani Willis and Georgia against Trump and various people is so significant, is that even if Donald Trump is reelected, he can't pardon people in those state proceedings. He can pardon anybody he wants to about the federal prosecutions, but not the state prosecutions. And somewhere between 90 and 95% of all criminal cases in this country are state prosecutions. So yes, the president is given this very important prerogative power that was vested in the king, but the Congress was careful to limit it in ways that make it much less potent and therefore much less likely to be a serious problem for the republic. I think I'm going to stop here because I feel as though I've been droning on, and I see various people's faces are going down into the cheesecake, and I don't want to do that. So I'm going to bring this to an end. But I want to say that I think that the original plan for the presidency was extremely well thought out, and I think it's a shame that we don't study it more. And that people aren't taught how it came about and what the theory of the presidency is, because I think it's really quite ingenious. And I think I will leave you with what might be an apocryphal quote, but I like it anyway, from Mahatma Gandhi, who was asked what he thought of the United States Constitution. And his response was, I think it would be a good idea. I don't know if you wanted questions or if it's just too late.
I think no, it was great. Thank you so much for
no questions.
No questions, yeah. But you can stay here. Thank you so much for your remarks. I think it's timely reflections and important as we consider the Constitution, so we're really grateful for that. As you all know, tonight is our Daniel H. Utley Memorial Lecture, and we have 3 members of his class with us this evening. So if Ryan Newcomb, Connie Toby, and Neil and Milana Salyer would join us to come forward and help me present the challenge coin to Judge McConnell. Thank you for coming out tonight, and to those of you watching online. For other McConnell Center podcasts, videos, and publications, please visit the mcconnellcenter.org. Thank you, and have a great rest of your evening.